you would swear that conservatives, they don't have major donors who give millions upon millions to their candidates. I mean, you've got Steve Schwartzman, of course, CEO BlackRock. You've got Miriam Adelson, of course, her husband was alive, Sheldon Adelson. I mean, they give hundreds of millions of dollars. You've got the Koch brothers. One has died, but you still have one of those brothers. I mean, you got these billionaires out of Wiley, Texas. I mean, they pump hundreds of millions of dollars into our political system. But for the right, oh my God, George Soros must be the devil. I mean, they slap his name on every single thing you could think of. Well, when the 2-to-1 ruling came down, declaring that the Texas map that was approved was racist gerrymander, the one judge, in the 2-to-1, oh my God, Judge Jerry Smith lost his mind. He was so angry, he was upset, he felt they didn't give him enough time. But when you read his report, I mean, he trashes the other judges. And mind you, one of the judges he's trashing is a Trump appointee. This dude is a Reagan appointee. But one of the folks who he really was upset with, is my next guest, Matt Libretto. I mean, Jerry Smith, y'all, was just losing his mind. He said this was the most blatant exercise of judicial activism I have ever witnessed. And he sat there in his ruling. I mean, he was just going on and on and on, Soros and Soros and Soros. And he was really upset with Matt. Matt's professor of political science and director of UCLA's Voting Rights Project, who joins us right now. And Matt, I've been wanting to talk about this for 2 days. You could only join us today. I said, man, let me hold my powder. But it was hilarious reading this white man's meltdown, because he just could not help himself. He really portrayed George Soros like he's the devil.
Hey, Roland, it's good to see you. Thanks for inviting me back. It was an intense trial, I'll say. There was thousands of pages of evidence that went in. And you mentioned the other judges in the 2-1. They sifted through that evidence and they looked at all the testimony. You had state legislators from both the Democratic and Republican side. You had statements from Governor Abbott. You had expert reports that I was part of. And there were thousands of pages of evidence and testimony delivered to this court. And Jeff Brown, who wrote the 160-page opinion, sided with the plaintiffs and said, as you just said, this was a racial gerrymander that violated the Constitution. So there was plenty of evidence. There was no need to, invoke anything that wasn't a part of the trial. But that's what we saw recently. And I think I was as shocked as anyone.
Well, and again, I mean, he was just going crazy. And I'm sitting here going, okay, he's bringing up, Soros funded this and he funded that, and Matt got money from here. And I was like, dude, that has nothing to do with the merits of the lawsuit. The lawsuit was simple. The people who sued said this was a racist gerrymander.
As I said, there was so much direct evidence. There were statements by Governor Abbott calling for the dismantling of Black and Latino districts. There was a letter from the U.S. Department of Justice telling Texas, you need to dismantle Black and Latino districts. And there were statements from state legislators who passed the bill saying they wanted to dismantle these coalition districts. So the direct evidence was quite clear. And then people like myself came in with a lot of statistical evidence, maps and GIS layers to look at where the line boundaries were. All of the evidence was very clear in this case. This was racial gerrymandering. They dismantled Al Green's old district in Houston. I know you know that district, Congressional District 9. So there's no question that the direct evidence that was at play here, as well as the effects evidence, was quite clear. And that's why you saw such a powerful 160-page decision in favor of the plaintiffs striking down the Texas map. And I can say I was there for the entirety of the trial. George Soros never made an appearance in the trial, and that had nothing to do with the direct evidence that was present.
Look at this. The main winner, go to my iPad here. The main winners from Judge Brown's opinion are George Soros and Gavin Newsom. The obvious losers are the people of Texas and the rule of law. I dissent. And then he goes on and on and on. And then he goes, the resulting dissent is far from a literary masterpiece. If, however, there were a Nobel Prize for fiction, Judge Brown's opinion would be a prime candidate. And so, boy, and then Judge Brown could have saved himself and the readers a lot of time and effort by merely stating the following. I just don't like what the legislature did here. It was unnecessary and it seems unfair to disadvantaged voters. I need to step in to make sure wiser heads prevail over the nakedly partisan and racially questionable actions of these zealous lawmakers. Just as I did to the lawmakers in Galveston County in Petaway, I'm using my considerable clout as a federal district judge to put a stop to bad policy judgments. After all, I get paid to do what I think is right. Okay, here's what's so stupid. The idiots with the Trump Department of Justice sends a letter saying, hey, it's some racial issues. Y'all got to get rid of these districts. Now, mind you, while that was happening, Texas was literally defending those very districts in court over the 2021 lawsuit saying, oh, no. We did not draw these seats with racist intent, with racial intent. Then all of a sudden, letter comes, Trump calls Abbott, yo, I need 5 seats. Flip it. Abbott, in his proclamation calling for the special session, cites the DOJ letter. The chair of the committee, the commission, cites the DOJ letter. Then all of a sudden they went, oh shit. The court ruled that partisan gerrymandering is okay, but it's illegal. Racist gerrymandering. Oh, damn. Oh, no. Oh, no. We're not doing it because of the letter. What letter? What no letter that came? What letter? What you talking about? What no letter? Oh, no. And then, while that's happening, Abbott goes on Fox News to defend the new map and goes, oh, no. This is not racist. We're creating opportunities for new Latino districts. I'm sorry. So that's really what Judge Brown was referencing. He was like, wait a minute. Y'all said it in writing and out of your own mouths what you were doing. And now you're claiming that's not what you're doing?
If people read, that was an excellent summary. It's funny because it's unbelievable, some of the statements that were made. If people read the 160-page decision striking down the map that Jeff Brown wrote, I've appeared before Jeff Brown 3 times in this trial at 3 different occasions. He is the most thoughtful, considerate, careful judge I've ever been before. He asks questions of all the witnesses. He asks for clarification. And his decision is very well reasoned. He is citing, just as you indicated, Roland, in the decision, he is citing the speeches given by Governor Abbott. And contrasting what he said on Fox News with a speech he gave on CNN, where Jake Tapper said to him directly, isn't this just about partisan politics, Governor? And Greg Abbott said, no, Jake, this is about dismantling the Black and Latino coalition districts, which are now illegal. He had a chance, and he actually said no. And that quote is in the decision, because that shows you what they were actually about.
Right.
They wanted to dismantle 5 Black and Latino districts. It wasn't about partisanship. It was about race. And those direct pieces of evidence are very, very clear. The lawyers who put the evidence on were brilliant, and that comes through in Judge Brown's decision.
So give me 1 second, because I gotta read this here. I love this here. It's all politics on both sides of the partisan aisle. George and Alex Soros have their hands all over this. One of the plaintiff's top experts is Matt Barretto. He is a paid Soros operative and does not attempt to hide it. His CV confirms it. He expects to receive $2.5 million from George and Alexander Soros. Nor is this something new. Soros has been pumping money into Barretto's UCLA voting rights project for years. And this steady supply of money won't stop until 2026 at the earliest. Unsurprisingly, Barreto has been on quite a roadshow for years, parading across the country opposing Republican redistricting. That is the tip of the iceberg. The lawyers are involved as well. And then he goes on and on and on. To his credit, the lead counsel for plaintiffs does not try to hide it either. Chad Dunn acknowledged so in open court. He works with Barreto at the same voting rights project that received Soros funding. Dunn is a respected attorney in Texas election law cases, most recently serving as counsel in the Jackson case. And then he goes on and on and on and on and on. And he goes on and on and on. He said it does not stop there. The Elias Law Group draws from the Soros coffers too. Counsel for the Instant Gonzalez plaintiffs, David Fox, is a partner at Elias, which has, quote, collected more than $104 million from Democratic Party committees and donors, including Mr. Soros. And he just goes on. On a silver platter, Judge Brown hands Soros a victory at the expense of the people of Texas and the rule of law. Judge Brown won't tell you that. I just did. And I'm sitting there going, so is he saying that no one else can give money to voting rights projects? That, is he, again, can I substitute Allison? Can I substitute Coke? Can I substitute the wild? I could go on and on and on, but he's clearly showing his disdain for there being people who oppose racist gerrymandering.
Yeah, there's no question that the Constitution, this wasn't even a voting rights claim. This was not a Voting Rights Act 1965 Section 2 claim in Texas. This was a claim against the United States Constitution, 14th Amendment. That's what Texas lost on right now. And if we cannot have independent research centers and litigation outfits that try to protect the United States Constitution, then I don't know how we're supposed to protect our democracy. That's what our group does. We try to stop racial gerrymandering at every turn. We try to make sure that all Americans, regardless of race or ethnicity, have an equal right to vote. And that's what people are advocating for. And there's nothing wrong with that. We're trying to uphold the Constitution. In fact, this Judge Brown in Guadarrama, 2 federal judges, evaluated a week's long worth of evidence and said they agreed with plaintiffs that the Texas map violates the U.S. Constitution. And so those of us who are on the side of trying to protect voting rights and voting equality, we should be celebrating this decision because you had both a Republican and a Democratic appointed judge in Brown and Guadarrama come to an agreement after reviewing thousands of pages of evidence and hearing testimony and saying it was clear to them. It wasn't even close. To them, it was clear in all instances that there were 6 districts that violated the U.S. Constitution because of racial gerrymandering. And that's something not to be ashamed of. That's something to be proud of when you can hold the state accountable and tell them that these districts are taking away the rights of blacks and Latinos in the state of Texas. The Al Green district will now get put back. That district in Houston, which has been there for decades. The Latino district that Greg Casar represents from Austin to San Antonio, that majority Latino voting rights district, will get put back. And people will have their representatives in Congress now.
So now the question then becomes, will the Supreme Court, first of all, this decision has been appealed to the Supreme Court. So the question now is, will the Supreme Court lock the new map in place? Or will they lock the old map in place? We also have, though, the Louisiana case. Is it pronounced Cali? Is that how they pronounce it, or Calais?
Calais.
Calais, I'm sorry. Calais. So you have the Calais case. So now, and then if they rule on that, that could impact these Texas seats. So just explain to people what we're now facing, because the conundrum that we're now in is today's November 21st. The deadline to run for these congressional seats, or even for the Senate, is December 8th. So, and I had Representative Jelana Jones on the other day. So the problem that we're facing is, well, if you're Congressman Al Green, do you file for the 9th district based upon the old map, or do you file in the 18th because of the new map?
Right. So as you correctly pointed out, this is coming up in about just over 2.5 weeks will be the end of the filing period to declare where you're running. And these cases are all going to the U.S. Supreme Court. As of now, the federal district, the 3-judge panel in Texas has enjoined the new map. So the 2025 map is on pause, and they say in their order that the elections will take place under the 2021 map. However, it's going to the U.S. Supreme Court, and the U.S. Supreme Court is going to have to decide quickly. So I think most experts and lawyers, and this is out of my sort of wheelhouse because I'm not a lawyer, I'm a data scientist and an analytics person. But what I'm hearing and what I've been reading is that they're expecting that decision in December so that it can come before the deadline. So that means this is going to move quickly. There's going to be both sides, the Texas Attorney General and the plaintiffs will explain and file their papers to the U.S. Supreme Court. The U.S. Supreme Court is going to get this. They're going to read all the opinions, and then they're going to have to decide. Remember, they cannot change the facts of the case. That's why this Jeff Brown decision is so important, because he established through 160 pages, along with Judge Guadarrama, that these are the evidentiary findings of fact. The Supreme Court can interpret whether or not they made any legal errors. But they have very clearly laid out why this is a violation of the United States Constitution. This is not a Voting Rights Act case per se. The Calais case, the other case you mentioned out of Louisiana, is a direct Section 2 voting rights case, and that is already pending before the Supreme Court. Most people think that they might take their time. They may not decide until the end of their term. You know how it is, Roland. A lot of times those big decisions come out in like June 25th, June 30th, right at the end of the term. Those bombshells. And so people are thinking maybe they're going to wait, but that is going to be to decide whether or not we have a Voting Rights Act anymore, whether or not we have Section 2, which has protected historically the creation of every African-American district in the South, has been as a result of Section 2 of the Voting Rights Act. And the Supreme Court could say, times are changing, we don't think we need it anymore. And so that's a very, very scary decision that's on the horizon. But these things are all before the Supreme Court. And we're going to decide, and we're going to hear whether or not we have a right to equal representation or
not. Question for my panel. I'm going to introduce them. Candace Kelly, she's legal analyst and host, Not All Hood, joining us from South Orange, New Jersey. Also, Michael Imhotep, host the African History Network show out of Detroit. Candace is a lawyer, so she gets first dibs.
Well, listen, I think that this was really interesting, the way that the dissenting opinion talked about the judge. And it was really something that was surprising how he went off. And I just want you to kind of address how really kind of a spectacle this is and how really unusual it is that on this level, I mean, he called the other judge an unskilled magician in all of this. This is very abnormal. I just wanted your comments about how you feel his response has hit and how unusual this is for the public.
Well, it's quite unusual. I haven't seen something like that in all the time that I've testified. As I said, I've been in front of Judge Brown and Judge Smith 3 times. I found both of them in my personal interactions with them to be very professional, very respectful. But this decision seemed to have more than just weighing the evidence, as you just noted. It's quite unusual. Our job is just to try to present evidence as the people involved in the case, and the judge is supposed to weigh the evidence. But this was quite unusual in that there was not a lot of weighing of the evidence. There was more name calling, and especially I found it unusual attacking another Republican judge, his colleague in the state of Texas. It was quite unheard of.
Michael?
All right, Professor Matt. The question I had, and maybe 2 questions. So I know that, as Roland said, that there's an appeal to the U.S. Supreme Court that was made Tuesday evening, Tuesday night. So dealing with primaries, we're dealing with time constraints because the ballots from the Secretary of State have to go out at a certain time because you have primaries first. So you have to have the names of the people on the ballot. You have to have the districts, all that sorted out. So if this is appealed to the U.S. Supreme Court, do you think there will be a ruling in time so that the say they uphold the federal panel, what they ruled, okay, that the districts are biased against African Americans and Latinos, right? Do you think there's enough time with the Supreme Court ruling to have the proper districts on the ballots, or sometimes you deal with a situation where there's not enough time to change it, so then you have to go with something else? What do you think will happen if this gets appealed, based upon time constraints?
Yeah, that's a great observation. And there is something called the Purcell principle. This is a legal standard that the Supreme Court has determined that if you get up too close to the election, let's say it's a week before the primary, they're not going to let you change the districts. In this particular case, we still have plenty of time because the filing period is still open. Nothing has run out of bounds. And if the Supreme Court is able to issue a decision during December, we should be totally fine. In fact, at the trial, someone from the Texas Secretary of State's office who administers elections testified. They testified on behalf of the state of Texas saying that they wanted to move things along. However, during cross-examination, that person stated that if the court ordered them to extend the period by 2 weeks or a month, they would be able to do that. And in fact, that had happened before in the state of Texas. And the person responded, yes, if the court orders us to extend the period by 2 weeks or a month, that will be no problem. We can certainly do that. So we still have enough time. That primary is in March. If things start creeping into February, that's where I think you're going to start raising alarm bells. And that's why most legal advocates and scholars want to see a decision by the Supreme Court to clarify in the month of December. If that happens, I think we're fine. But people should assume right now the Texas map has been enjoined. It's been blocked. If you're thinking of running for Congress, if you're an incumbent, I'd be filing in my current district because you're under the 2021 map as of right now.
And the concern that people also have with the Texas, because Texas can also move the primary. The primary right now is slated for the first Tuesday in March. The reality is, to your point, if a judge says, hey, move the filing deadline to, let's say, February 1st, they can literally move the primary to April, May, or even June. But the whole point there, and this is where Purcell comes in, and what people also got to remember, lower courts ruled that in Louisiana, that the state discriminated against African Americans by not creating a second district. Same thing in Alabama. But because of Purcell, the court locked the maps in place. So even though the lower courts had ruled those were unconstitutional, they declared, even though I thought in the Louisiana case it was bullshit, because their primary wasn't until August, that thing came down early in the year, they ruled that, hey, there wasn't enough time to change the maps. And so many folks are hoping that this Supreme Court, and we know that they care about precedent but don't care about precedent, are thinking that, hey, there's no way they're going to sit here and have this upheaval and say, yeah, let's go forward with these new maps, knowing full well people don't know what district I'm in, who am I voting for, where am I filing.
And if you look at the Brown decision, they have an entire 10 pages at the end of that directly addressing Purcell and timing. So they've laid it all out. Brown has written a very well-reasoned decision that takes on Purcell and the timing. And he says in that decision, we have plenty of time. Things are moving forward. The primary's not till March. We're good. So now the Supreme Court needs to get involved and tell us what the decision is. But I would expect the most likely outcome is that we will have the 2021 map. We will go back to that, and we will be able to see people file and run in those districts. On
another note, Matt, you look at this the data all the time, and in this, we saw in the election a few weeks ago, complete change when it comes to Latino voters. We're seeing right now where Trump is as well. And is this one of those things where buyer's remorse, where Latino voters are like, damn, we got played. They fell for the okie doke with Trump. Trump promised all these sort of different things, and his horrific attacks when it comes to ICE, how they're just snatching people and just abusing people. Is that what's really driving this significant drop in Republican Latino support?
Well, I think, first of all, let's document it. There was a poll just last week, showing that Trump's approval with Latinos was down to about 28%. It was under 30%. We saw that in the elections that you mentioned in Virginia, in New Jersey. We saw it out here in California in the Prop 50 vote. huge turnarounds going back almost to the 2020 numbers or before, even to the Hillary Clinton numbers in 16 in some of these places. Some of these places, Roland, 50-point net turnarounds in the Latino vote. And we know that Latinos are very economically conscious. We know that people were still hurting at the end of 2024, that inflation was still there. This is a working class community, by and large, had not fully recovered. Inflation was still there. And as you said, maybe believed a lot of the promises and those hopes that Trump said he was going to instantly change things. But that's not what happened. What we have seen is the economy has not rebounded. Latino wages have not gone up. Inflation continues to rise. Healthcare is expensive. Housing is expensive. We haven't seen an increase in Latino home ownership rates. Instead, you have seen unbelievable crackdowns on immigrant rights and immigrants, including U.S.-born and legal permanent residents and people with visas getting abducted, getting tackled by masked agents. That does not play well while simultaneously the economy is not rebounding. And so you put it together, those things are really at the forefront. I think a lot of people are saying this is not what we expected. We took a chance. We were hoping that this so-called businessman would help rescue the economy, but we haven't seen that, and people are upset. And I think what you saw in 25, man, it looks like it could continue into 26, and that won't be good.
Well, and that's one of the reasons why Republicans are desperate to gerrymander as much as they can, because I think they are expecting they're going to lose 10, 12, maybe 15 seats. It could be even more. So I think that when I see these folks in these Muslims in Dearborn, Michigan, who are angry with the right wing, protesting them, when I see what's happening with ICE, I think between those voters and Latino voters, they're sitting here going, damn, I think we screwed this one up. And the problem is he's going to be there for 3 more years. So we'll see what happens in the midterms. Matt, we appreciate it. Thanks a lot.
Hey, Roland, anytime, my brother.
Hello, I'm Isaac Hayes III, founder and CEO of Fanbase, and I'm here with a very important message. We are at a turning point in the Black community where we must have equity in the apps we use that scale to billions of dollars. But this time, we own the infrastructure, we own the culture, and we shape the future. And Fanbase is the future. Fanbase combines the free functionality of Instagram, TikTok, and YouTube into an all-in-one platform built for the evolution of social media and monetization. With over 1.4 million users, that's real proof that we are shifting the conversation of tech ownership and equity for creators. So right now, I want you to go to startengine.com/fanbase and invest today. The minimum to invest is $399. That gets you 60 shares of stock in Fanbase at $665 a share. This marks a turning point in Black ownership of social media. If we don't take this opportunity to own social media right now, we will always be customers to our own creations. And that can't go on. So once again, go to startengine.com/fanbase and invest today. We must own the platforms where our voices live, our stories matter, and where our culture drives the world. Thank you.